Jobs. Hey, big deal in this current economy, and that takes us to this week's case. Case that started back in 2006 involved a woman who was happily employed as an attorney working for a firm. She was approached by a headhunting firm, organization called Waverly Partners. This is down in North Carolina. They approached her and said, hey, you know, you're doing pretty well as an attorney, and we would like you to consider getting a different job because we think you can do better in your career. They, of course, are going to make some money as a result of a placement fee. She said, well, you know, there's no harm in looking around, but I'll tell you this. When it comes to getting information, I don't want you guys to go out and talk to my current employer, because if you do, because things are getting a little shaky right now, if you do, I will probably get fired. And I don't want to get fired. I'm relatively happy here. They said, no problem, don't have to worry about it. We're going to protect your confidentiality. So it moves forward. Well, as they're working up her resume, they want to get additional information, verify the kind of employment that she had, and get people who worked with her in the past that will say good things about her and what she can do, so they want to contact them. They have her sign a consent form that says, we have the ability to contact your prior employers. She signs the form. And they then give that to their investigators. They go out, they investigate, they talk to prior employers, they talk to prior people that she worked with, and putting together a decent resume. And then one of their investigators contacts her present employer. Present employer becomes aware of the fact she's looking for a job, and she is fired right then and there. Fired right then and there. She says to the headhunting firm, Waverly Partners, guys, you really ripped me off here. You violated the confidentiality I gave you. They said, wait a second, we have a waiver that you signed, and that waiver allows us to contact prior employers. She said, that's true. It's prior employers, not current employer. I gave you no ability to contact my current employer. They said, we think prior employer includes your current employer. She said, you got to be nuts. And she sued them. She sued them, saying, hey, I right now am out here unemployed in a horrible economy, because while this all started in 2006 when she was fired, the economy tanked. Absolutely cratered in 2007, as we're all aware. Couldn't find a job. So she sues them, saying, you guys really screwed up my whole career, and I am looking to you to be reimbursed all the lost income I've had and the fact that I can't get a job right now. They said, we don't owe that, you signed this waiver. Well, the case went to trial. There the same arguments were made. They said waiver, she said waiver was for prior employers, not for current employer, and the jury heard the case. Jury listened to the evidence, and the jury came away awarding $1.6 million in lost income to this attorney, saying that she, in fact, had given a waiver, but the waiver was for prior employers, not for current employers, and accordingly, they, Waverly Partners, violated her confidentiality. Okay, so what do we learn from this? What do we learn from this? We learn something that we all know, and that is when it comes to agreements, you need to see what the agreement is actually saying. There's a world of difference between prior employers and current employer. And in this instance, that difference was not honored by, in this instance, the defendant, Waverly Partners. So when you're looking at contracts, pay attention to what's going on, and basically use some common sense and use the language the way we use it every day. There's a difference between prior and current, and in this instance, that difference made a difference of $1.6 million. We bring you this case, hey, as we bring you cases every week, so you understand how the law works. I'm David Allen.